Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I am a Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Well, thank you for that wonderful introduction. I appreciate it. And I've now been speaking with SunRay and giving these presentations for a few years and always enjoy talking to people. Your customers are the ones who know what it takes to get paid, understand the importance of these things. So hope I can give a little bit more information today that's going to help them make sure that they were using best practices to get paid and give them some benefit here. So without further ado, I'll jump right into the presentation. So during the presentation, if there's any questions, you can go right to the chat box and leave it there. I'll answer any questions that there are at the end. Please make sure to keep it general and not use company names. So here's what we're going to go over today. Just a couple of points about your contract, making sure it passes this important checklist, how to secure your mechanics lien rights in Massachusetts, an overview about bond rights, lien and bond rule exceptions, kind of traps for the unwary, what to avoid, and the right way to get paid. It seems like just taking money is good, but when you've got lien and bond rights that are in question or maybe expiring soon, how you get paid is really important to make sure you don't wind up with a bad check and then no lien rights. So check your contract. First, unfortunately, this is a in January let you know and not in Massachusetts. In your contract to be able to for your contract for non-payment, for example. You will get statutory interest in Massachusetts at 12%, which is fairly high across the country. So if you're happy with 12%, that's fine. If you want to have any other, an additional interest charge, some people do 1.5% a month, which would be 18% a year. If you want a particular late fee, you can do that, but those things must be in writing in your contract. But the basics of the contract should always be there. You want to have proper full identification of the parties. That means legal names. Make sure to include whether it's an LLC or incorporated entity. If you cannot find them in the Massachusetts database, check the Secretary of State's database online. It's a free search. If you can't find them there as registered as a incorporated entity or an LLC, you may find that they are not registered to do business in Massachusetts. And maybe a foreign entity. They should still register in Massachusetts, so you should be able to find them. The biggest concern, of course, is that if you end up dealing with somebody who may go by a business name, but is in fact only a sole proprietor, then you have to consider what type of resources they have, and is this somebody that you want to continue doing business with? So full legal names is really important in the contract. You want to make sure that you have signatures or have some way in which you can show that they agreed or approved this. If someone's sending an email, Massachusetts case law has made clear, if I send someone a contract and they respond back in email, yes, that's great, I agree, please go ahead. That's effectively the same as having a written contract that's been signed by that party. However, you want to make sure that that email has indicia of reliability, is what that's called. You want to make sure it comes on an email address that you're familiar with as being that person's. Want to make sure that it's clear that they're saying that they agree to it and it's clear what they agreed to. So if you sent over 5 documents and they just respond, yes, that's not a clear assent in my mind. In that case, I would want to go back and either clarify or want to get a signature on the document. DocuSign, typed signatures, those are fine, especially after COVID. So use the resources at your disposal disposal. But please make sure you do get a signed contract. That is a requirement in order to file a mechanics lien in Massachusetts, which is that incredibly powerful tool to get you paid. Your contract should also have a detailed scope of the work, so you understand what you're required to do and what you're not. What is outside the scope of the contract, the only way you can do that is have that detailed scope of work. And make sure you include the job address. That's going to become more important as we talk about mechanics liens. So payment terms, in addition to what we talked about earlier for interest, late fees, and attorney's fees, other payment terms like when is it due, and then, of course, most importantly, how to get you paid, where to pay you. Those are things you want to make sure that are included in your contract. You may find that you have a credit application early on, and then they just let you know which project things are being purchased for. If you are a supplier, for example, in that case, you can still have all those terms and that signature show up in your initial contract, your credit term contract or agreement. And then subsequently, they're going to identify what the project is, what you're selling. Maybe those are your invoices or your purchase orders. If you are a subcontractor, then you've got probably a more clear subcontract agreement for each project you're working on. So if you aren't paid, you have breach of contract rights, and you can pursue those within 6 years of the date of the breach. Typically, it starts with a demand letter. I like to get these from an attorney because they have a lot more impact to them. That's letting somebody know that you're ready to proceed and can file suit if you need to and have the resources. So getting a demand letter out from an attorney is a great way to start. It's low cost and might engage in an early discussion that either tells you what the issues are and why they're not paying, or it gives you an opportunity to see if you can negotiate that early before you've incurred the expenses of filing suit. If that demand letter doesn't work, then the next options would be filing suit or any alternative dispute resolution provision that is in the contract between the parties. So that's your contract rights and how you would pursue those to get paid. Let's go into the lien and bond rights. Mechanics liens and bonds are a fantastic way to add some ability to get paid that is a lot more powerful than just suing on a breach of contract. So mechanics liens in Massachusetts are for any construction work done on private property for which you have a contract. If you've improved the property either by doing services or providing material that was used in that property, then you are entitled to get a lien to make sure you get paid. The ultimate effect of a mechanics lien, if it is initiated correctly, pursued through the end, is that at the end of the day, you obtain a judgment to sell the property in order to satisfy your lien. It's an incredibly powerful tool, and it's expedited over a lawsuit, which may take years to put through the courts. This gives you something tangible to get paid from. You are typically going to be behind maybe a mortgage on the property and any other encumbrances that come before you in time, but it is an incredibly powerful way to get paid. So enforcing a lien, going back to what I said earlier, you need to have a signed contract and you need to know the parties who are on the job. It's good to have an identification of the parties on the job as well in terms of their roles. To know, are you a subcontractor? Are you a sub? Are you supplying a contractor? Are you the GC? What is important? There are small differences depending upon what tier you fit. It would be great to know the owner of the project. Are helpful explains, but always to figuring what you need to have a project that would be great. Time mechanics lien is key. It has a very strict and expedited time frame. People use in a process. So is although there are things like a substantial completion, notice of termination that he filed in my 20 years of doing construction law, I've only seen 1 or 2 notices of substantial completion or notices of termination that are recorded, which change timing. If there are any anything or someone is talking about a notice of potential going to get recorded, or a notice is going to get taking a look at your deadline because they're going to be a little bit quicker based on the dates those are filed. You generally from those dates to do your filings. But a vast majority of mechanics liens are going to work from the date of you're going to have the benefit of the last performance of anybody who's operating under the general contractor's umbrella. So for example, if you are the painter on the job, if you are the person who lines the parking lot, your last date of performance on that project is going to be the same date that you count your deadline from as the person who came in first and put down the foundation, or the person who supplied the rebar for the foundation. Those people are early into the job, but they have just as much time as the last person. So you may not know when the last person finishes their work. I always suggest to my customers and clients that they track their last date of performance. So physical performance, doing contract work, not warranty work, not punch list work, but actually doing work, or the last date that they supplied materials to the job, because that will give you at least a deadline you can prove for the last date of work. If you need to, you may have some grace period because you know somebody was working after you. We may not know exactly when that is, but it can give us a little cushion. As long as we first have the idea of when your last date of performance was, that's going to be helpful. And keep in mind, it's not last date. I've seen people get tripped up on the dates of the invoices. Always want to check to make sure, supplier, that it's the date of delivery. Or if you were doing work on the project, again, it's the last stand work on the project, not punch list, not cleanup work. The key metrics here is it's 90 days from the last date of work on the project that you must record a notice of contract with the registry of deeds. The second filing is called a statement of account. It identifies how much is due. That filing must be made and the statement of account must be recorded with the registry of deeds within 120 days of the last date of work on the project. Something to keep in mind is if you wait till close to the last day for the notice of contract, then you're going to be about 3 days later needing to file a statement of account. Statement of account and notice of contract can be filed together. One reason I don't suggest doing that is that the last filing that needs to be made is to file suit. Filing suit is required to happen within 90 days of the date that the statement of account is recorded with the registry of deeds. So if you gave the notice of contract, it's full 90 days. If you gave the statement of accounts full 120 days from the last date of the project, then you have 90 more days to file a suit, and the process has taken some time. You can also go ahead and do the notice of contract from as soon as you have written contract executed. Don't sit without any action being on it until you want to file a statement of account when there's a balance due that you want to get paid on, as long as that's within 120 days of the last date of work on the project, and then 90 more days to file suit. If you do everything all at once and file the notice of contract on the same day as the statement of account, then you're simply going to have only 90 more days before you must file suit. There is notice that's given. That's something that can be handled. Typically, it can be handled for you. You can take care of that responsibility. But if you are not in a direct contract with the owner, then you're going to need to make sure that the owner has notice. So you're required to give notice that you have filed the notice of contract. If you are a subcontractor or a supplier who does not have a contract with a general contractor, so you're going to want to send a notice of identification. It'll help you get the full value of the lien, because otherwise the owner and the general contractor have no idea that you're out there, and they could keep paying monies along without looking for a lien waiver or without any indication that you're there. So the law says, in fairness, if the owner and the GC don't know about the lien, then they can't be held responsible to pay twice. So you would be limited typically the amount due or to become due to the contractor above you at the time that notice of the lien is given to the owner. If you've done the notice of identification, it pushes that date back to the very beginning of the project. If you have a large project and think a notice of identification is appropriate for you, definitely reach out and ask some questions about it. See if it is in fact appropriate. Perhaps for the unwary, it is your obligation to prove that the materials were used on the particular property that you want to lien. So if you have a general job account, make sure that you are using delivery addresses or you are using project addresses, and that those things are checked with each order. Delivery to the job site is best, and signed delivery slips are obviously the best. If you don't have those, at least keeping track with tickets or some record that this is what you delivered is going to be very helpful. Please don't wait until the last minute. I know we talked about 90 days and 120 days. It does take time to make sure that you have all the information you need, that you've got the recording information. You have time to get this on record with the registry and time to prepare and have the notice of contract and statement of account notarized by the company who's filing it. So give yourself time. Don't be waiting until 90 days. Start looking ahead maybe at 60 days and say, do I have an outstanding receivable? What do I want to do to collect it? Is this the type of lien that's valuable enough? Is this type of debt that's valuable enough? Do I have the right to collect on a mechanics lien? Is that how I want to go? But be making those decisions either early on in the project or at 60 days. And just keep in mind, getting close to the wire, close to those deadlines become an issue. You don't want to be left with a check that is no good, a check that bounces, and then your lien rights have expired. There is no opportunity to go back to the court and say, but they gave me a check and it only bounced after the deadline. Take wires, get something if you're going to release your lien waivers, or continue to pursue your lien and then take it off only after you verify that full payment has been received in good funds. So quickly about bond rights. The things you may realize when I talked about mechanics liens is these are for private property. If you are doing work for a public entity on public property, the law in Massachusetts requires at different levels of horizontal and vertical building that they are required to post bonds. Some of the bonds may be 50% of the project. Larger projects will require 100% of the contract value to be bonded off. You are looking for payment bonds. Performance bonds are what guarantees to the owner that the work is ultimately going to get done. It's important that you understand where you sit in the bond relationship. Typically, the bonds are going to be posted by your general contractors. Try to get a copy of the bond at the very beginning of the project before things go bad. That way you can see what it requires. You can see if there's any deviation or any special notice provisions. If not, generally you can assume that if you are a subcontractor or lower, you're going to need to give notice within 65 days that you haven't been paid. And then generally you're going to need to file suit within 1 year. And those are the statutory requirements for statutory bonds. Bonds are only statutorily required on public construction projects at certain levels, but they can be provided on private jobs. If you find that it is a private bond, you may find there are different terms. Otherwise, if it's a bond required because it's a public property or public owner, then they're going to have the minimums of 65-day notice and typically 1 year statute of limitations to file. So one last point I just wanted to get to is how to accept payment the right way. Now, I would love buckets of cash coming in, but that's not how we do work anymore. So again, part of the idea is if somebody is telling you, I'm going to send payment and you're at your 85th day, you need to be making decisions about how are you going to get payment in that is going to make sure that you get good funds before your mechanics lien deadlines expire. It is permissible to take a check and still continue to pursue your mechanics lien rights and take that next step. Filing fees in Massachusetts are over $100 for your documents. I think it's about $105 or $125 at this point. So you want to consider, am I going to spend that extra $125 to know that I am certainly going to have a lien right if this check goes bad? Otherwise, require that they send a payment by wire. That's immediately available funds, and you're going to know if you have that money in your bank account in the next day. I strongly suggest that you be safe than sorry in a situation like this, because again, there's no petitioning the court to say, my lien rights did technically expire, but I got this check and they induced me not to file. The court will say no. It is strict compliance only. If you are given payment, you may also receive with it a mechanic's lien waiver or a release form. Take a look at that. A lot of those can have additional terms in it that are much broader than what you are agreeing to, which is, I agree that I've received this payment and that I'm going to release my mechanic's lien rights. That's the only thing that's necessary in a lien waiver. If you find that there's additional language that they're trying to slide in, ask somebody to review it and see how it does impact your claims. Oftentimes, these releases include a broad release of any rights that you may have. And we don't want that to happen. We want to make sure if you find out that you didn't get paid down the road for something because you forgot to bill for it, if you find that, we want to make sure that you haven't released those rights. Last thing is, if there ever is a release that you're signing that does encompass the whole project, have it be mutual. You want to know that your claims are resolved and their claims against you are resolved, that you don't have lingering issues that come up in the future in which you may be prevented, if you signed a one-way release, you may be prevented from pursuing something further while they are not. So with that, I don't see that we have any questions that came in, but I'm happy to answer questions at any time. My information's on the screen here. Feel free to always send me an email or reach out and call. SunRay is an excellent resource as well. You can always get in touch with them. And if they have Massachusetts questions, they do reach out and ask me as well.
We sure do, and you're pretty wonderful about it. I actually do have a question that was posed to me. I'm not sure if it was just directed at me or not. But the question was, what is the time frame after filing the lien to file the statement of account?
So the difference in that deadline, and that's a good question, is those first two filings, which is your notice of contract and your statement of account, those two are both based on the last date of performance. So if the last date of performance, for example, is January 1st, you have 90 days from January 1st to have notice of contract on record with the Registry of Deeds. And then your statement of account needs to be on record within 120 days of the date of last performance. So for your notice of contract, you're counting out 90 days from January 1st. And for your statement of account, you're counting out 120 days from January 1st. And again, you can file those together. I prefer to give them separation. It gives you a little bit more time before incurring that next cost of the next filing. But there's no specific time frame between one and the other. It's those first two filings both have deadlines, which are 90 days and then 120 days. And those are both counted from the date of last performance. It's only the deadline to file suit, which is tied to the last deadline, and that's 90 days from the statement of account is the deadline by which you must have suit filed in the appropriate court.
Perfect. And those dates and deadlines are all calendar dates, not our calendar days, not business days, correct?
Correct. There have been, Massachusetts law is clear. If there is a deadline that expires on a weekend or a holiday, you have until the next business day. So for example, if your 90th day falls on a Saturday, technically by using these other laws that exist in Massachusetts about timing and deadlines, you technically would have until the end of the day the following Monday to get that recorded. However, mechanics liens are always go back to the idea of strict compliance with the law. I would prefer to always be working within the 90 days as opposed to potentially pushing that a little bit. So for my money, if your deadline expires on a Saturday, I would always rather you treat that as a Friday deadline rather than giving yourself through the Monday.
That is perfect. Yes, please don't wait until the last moment. You put yourself at jeopardy. All right, so if anyone does think of another question that wasn't addressed, like Jessica said, please feel free to reach out. We'll be sure to answer any questions for you. On this slide, there are some of the SunRay resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next slide, if you don't mind, please. All right, our next webinar with Jessica is going to be March 19th. That's going to be what happens after I record my lien, how do I get paid? And then the next one after that is May 21st. Don't sign a release until it passes this checklist. Those, you can both register for either of those or both of them at sunraynotice.com/education. Please go ahead and register for free. We'd love to be able to see you there, and so we can continue the conversations with you. All right, and then the next slide, if you don't mind. All right, if you don't mind, give us take a moment to give us a review on Google. We really appreciate it. It takes about a minute of your time, but it helps us get some feedback on what you guys hear and what you guys are looking to learn about. We really love that. And then the last slide, if you don't mind. Wonderful. And with that, that is all we have for you today. Thank you so much for everybody who attended. We hope to see you at our next webinar. Again, Jessica, you really are incredible. Thank you so much for everything. And I hope you all have a wonderful and beautiful sunny day.